Hi friends, welcome to my YouTube channel Law Days with Reshma. Today we'll discuss two important cases relating to personal liberty. A.K. Gobalan vs. State of Madras and Maneka Gandhi vs. Union of India. In A.K. Gobalan case, the petitioner AKG, the famous communist leader, was detained under Preventive Detention Act 1950. The object of this act was to provide for detention with a view to prevent any person from acting in a manner prejudicial to the defense of India, the relation of India with foreign powers, the security of India or a state, or the maintenance of public order, the maintenance of essential supplies and services. Section 3 of the Act empowered the central and state governments and certain officers under them to make orders of detention if they were satisfied that it was necessary to detain a person with a view to prevent him from acting in any manner prejudicial to such causes. AKG was served with an order made under Section 3 Clause 1. Now, let me take a brief deviation and talk a few words about these preventive detention laws in India. Preventive Detention Act 1950 was originally meant as a temporary measure for 1 year, but it was extended from time to time till it lapsed in 1969. But within 2 years, another similar law was made, that is Maintenance of Internal Security Act or MISA 1971. It was repealed in 1977 by the Janata government. In 1980, the President issued the National Security Ordinance, which later went on to become National Security Act. Clauses 4 to 7 of Article 22 of our Constitution guarantees certain rights of a person arrested under preventive detention laws. Now, coming back to our case, AKG challenged both his detention and the act itself on the following grounds: that it violated his right to move freely, which is the very essence of personal liberty under Article 19, and that the act was in violation of Article 21. It was argued that the word law in Article 21 should be perceived to include universal principles of natural justice, and that Article 19 and 21 should be read together. He further argued that the expression procedure established by law was synonymous with the concept of due process of law of the American Constitution. This matter was heard by a 6 judges bench. The court held his detention to be lawful and simply struck down Section 14 of the Act, which restricted the disclosure of grounds of detention as unconstitutional. Supreme Court interpreted law as state-made law and rejected the plea that it means principles of natural justice. It was held that personal liberty means nothing more than the liberty of the physical body, that is, freedom from arrest and detention without the authority of law. Justice Fazal Ali, however, gave a dissenting judgment. He gave a wide and comprehensive meaning to the words personal liberty. But over the years, there was a shift in the interpretation of personal liberty by Supreme Court. In 1963, in Kharak Singh vs. State of UP, Supreme Court held that personal liberty was not only limited to bodily restraint, but was used as a compendious term, including all varieties of rights which go to make up the personal liberty of a man other than those dealt with in Article 19 Clause 1. Finally, in Maneka Gandhi vs. Union of India, Supreme Court gave a wide interpretation to the term personal liberty and overruled A.K. Gobalan's case. On July 4, 1977, Maneka Gandhi received a letter from the regional passport officer intimating that it was decided by the Government of India to impound her passport under Section 10 Clause 3 Subclause C of the Indian Passport Act in public interest. She was not given a copy of the statement of reasons for the decision. She challenged the section as violative of Articles 14, 19 and 21. The Supreme Court held that the government was not justified in withholding the reasons for impounding the passport. The power conferred under Section 10, Clause 3, Subclause C is a quasi-judicial power. The rules of natural justice would therefore be made applicable in the exercise of this power. The court also stated that the procedure prescribed by law under Article 21 has to be fair, just, and reasonable, and not fanciful, oppressive, or arbitrary. It held that life under Article 21 includes right to live with human dignity.